Allison, I think we can go ahead and get started.
Yes, let's do. Thank you, Gavin. Right, we're going to call this meeting to order. I think, Gavin, I believe you're going to call the roll first. Is that the way we're going to proceed this morning?
Yes. I'm going to call two rolls. The first roll will be the names of the committee members and the alternates of committee members. After your name is called, would you please say here so we can make sure your microphone is working? So I'll start at the very top. Allison Ho, co-chair, you are here. Carrie Ricci, are you also here? We'll wait a little bit for Carrie. Alice Kottmeyer.
Here.
Thank you. Anika Cooper.
Here.
Thank you. Anna Shavers. Anna Shavers. Hi Feldblum.
Here.
Thank you. Was that Hi Feldblum or Anna Shavers?
Here
Shavers.
for I. Oops. Here for I and for N.
Okay.
Both of you are here. Great.
Yes.
Daniel Cohen.
Here.
Thank you. Elbert Lynn.
Here.
Thank you. Eloise Patsikoff.
Here.
Thank you. Erica Lietzen.
Here.
Thank you. Helen Serratio. Helen Serratio. Jack Bierman.
Here.
Thank you. Jim Tozy.
Here.
Thank you. Jennifer No. Jennifer No. Jesse Panuccio. Jesse Panuccio. Kenny Wright.
Here.
Thank you. Marion Zobler.
I'm here.
Thank you. Michael Cole.
Here.
Thank you. Mark Sochajewski.
Hi, Sakachevsky here.
Sakachowski. Thank you. Appearing as alternate for Patrick Nagel of the Social Security Administration. Thank you. Randolph May.
Here.
Thank you. Robert Girard.
Here.
Thank you. Roxanne Rothschild. Roxanne
Here.
Rothschild. Thank
I'm
you.
here.
Thank you. Russell Wheeler. Russell Wheeler. Great. Are there any other names of committee members that I did not call? Great. The second roll will be the names of ACUS members who are not on the committee or as serving as alternates. So those that RSVP'd. Bill Funk. Bill Funk. Andrew Emery.
Here.
Thank you. Jeff Lubbers.
Here.
Thank you. And Will Gunn. Is Will Gunn
Morning.
on with us?
This is Stephanie Davis from the Legal Services Corporation attending for Will Gunn.
Okay, thank you. All right, well, that's the role. Are there any other members of ACUS that are not on the committee that I did not call? Great. We would also extend our welcome to members of the public who are here listening. Great, so I believe I will turn it over then to Matt for opening remarks.
My opening remarks are really only to thank our committee chairs, well, first our two committee chairs for this special committee chairs for the standing committee meeting. Allison and Carrie, we're thrilled that you are giving us your time, and we very much appreciate it. And we're quite certain that no one can do it better than the two of you. And let me, if I may, publicly congratulate Carrie for her nomination to be the General Counsel of the United States Army. I have that right, don't I, Carrie?
Yes, that's right. Thank you. Appreciate it, Matt.
That's terrific. I at least am very glad to hear that, and I suspect others are as well.
Thank you.
And thank you especially to George Cohen, our consultant, who is one of the leading figures in legal academia on legal ethics and professional conduct. we're very fortunate to have attracted someone of his talent to work on this project. And we're especially appreciative that he was able to give us so much of his time and to work in recent months and to work under what's been a somewhat compressed time period. So thank you very much. And then I know the ABA, we have some representatives from the ABA joining us, and I thank them for joining us. And I would just say that maybe to Larson that I think it would be a good idea maybe after the meeting to provide us with any provide the committee with any written materials that you think it should see as part of the deliberations. So with that, I'm turning it over to, am I turning it back over to Gavin or Allison at this point?
Allison.
Okay, Allison.
Thank you. Thank you, Matt. Welcome, everyone. On behalf of my co-chair, Carrie and I, we're really looking forward to today's discussion. Because we're fortunate to have quite a few members, I think more than usual from the public, able to join in our discussion this morning, I'm going to go into a little more detail about our rules of the road than we normally would before I introduce Professor Cohen to give us a brief summary of his very important work that's the subject of today's discussion. I want to begin by noting that only ACUS members, including government members, public members, senior fellows, liaison representatives, and special counsels, whether you're on the committee or not, and their designated representatives have full speaking privileges. I'd also ask, although you think after months and months on Zoom, we wouldn't need these reminders, but I know I do, to please remain on mute unless you're speaking, and then please do remember to mute yourself after you've done. And to speak, we'd ask that you would use the hand raise feature or add a comment in the chat feature just to indicate that you would like to speak. Please don't have sidebar conversations or put substantive comments on the chat. We want to make sure that everybody on the line gets the full benefit of everyone's comments. And as per usual, we would ask that you use your webcam. I more than anyone know there are just times when you need to turn that camera off. So we certainly understand that, but to the extent you're able, we do appreciate keeping the webcam on, so we're not looking at a sea of names. With respect to attendees other than ACUS members and alternates, participation does require the unanimous consent of the committee members. Time permitting, I will consider calling on such attendees at appropriate points. And we're going to presume that the committee consents absent someone raising an objection. So that'll be the way that we'll proceed today. So again, just use Zoom's hand raise feature and wait to speak until I call on you. And you can then unmute yourself. And again, just please remute yourself when you're done. In terms of voting, only members of the ad hoc committee have a vote, and please don't vote unless you are a member of the committee. And Gavin and I have a list of committee members, in case you're unsure if we get to a vote today. So with those rules of the road out of the way, I'd like to turn the meeting over to Professor Cohen to give us a brief presentation, kind of hit the high points of his research to launch our discussion today. Professor Cohen.
Thanks very much, Allison, and thank you all for allowing me to have this opportunity to speak and to give me the chance to present this report. I am a professor at the University of Virginia School of Law. One of my specialty areas, as was mentioned, is professional responsibility. I am not an administrative law person, so this is kind of a different area for me, but I am an author of a case book with Jeff Hazard, the late great Jeff Hazard, among others, where we discuss, among other things, some of the agency rules. So I had been aware of some of them, in particular the SEC rules and the IRS rules and the USPTO rules. But several years ago, I was a participant in a symposium on the lawyering in the administrative state, and I decided to just explore what the range of rules were in different agencies. And I found that, first of all, no one had really done any kind of comprehensive survey of the federal agency rules beyond sort of the big three that I mentioned. That people had done individual agency studies and the like, but no one had ever even collected all of them. And so one of the things I tried to do was actually do that, to try to collect as many as I could. And I created a spreadsheet that listed as many rules as I could find, at least in the CFRs, and tried to figure out what was going on with these rules, what the nature of them was, and how the agencies were approaching this. And I think the big conclusion, which I've confirmed in the further research that I've done here, is the huge variety in practically every dimension that one could think of in terms of how the agencies approach the rules, the number of rules, the topics that are covered, the procedures that are used. And so I found that interesting and sort of published these findings. And then ACUS found out about this, and they decided to do the study and graciously picked me as a consultant for this. And the idea was to try to focus on a select group of agencies, try to get a better sense of the law in practice, how the agencies are actually implementing these rules. And so what we wound up doing was, as was already mentioned, a compressed time frame, conducted a series of interviews with 8 agencies that have rules of conduct, what I'm calling rules of conduct. And I greatly appreciate the time and the energy and the effort that the agency interviewees we talked to were willing to put in. And the agencies were USDA, DHS, SEC, FERC, Social Security, Department of Labor, the NLRB, and the VA. We also talked to the State Department, which does not currently have rules of conduct. And as I mentioned in the report, I also was able to take advantage of an excellent recent study by Professor John Lee in the BC Law Review in 2020, a detailed study of the USPTO disciplinary system and how they're implementing their rules. So what we tried to do in the interview and what I tried to summarize in the report was a variety of topics in terms of the both the structure of the rules, who can practice before the agencies, what the qualifications are, especially for non-lawyers, the way the rules are labeled, where they're put in the different agencies, what kind of coordination, it turns out to be very little, there is among the agencies, whether the agencies just draft their own rules or incorporate other rules. And again, there are a number of agencies that have incorporation rules, but often in addition to their own rules. I kind of did a little bit of a survey of the main topics that are covered in these rules that are reflected in the recommendations as well, and then talked about how the rules seem to be implemented, both in terms of how often you see discipline, referrals to other disciplinary authorities, reciprocal discipline, things like accessibility and guidance and the like. And then I tried to make some recommendations along 3 main topics that you'll see reflected in the recommendations from ACUS. The first topic being improving on information and transparency provided to both benefit the agencies as well as the practitioners and the general public. Greater coordination in a variety of respects, including making greater use of the ABA's National Lawyer Regulatory Data Bank and more coordination with Bar Council from the various states. And then the third being harmonization in various ways. And there are a number of ways in which one could do that in terms of focusing on style or language, focusing within agency within agency rules across similarly situated agencies, or trying to have greater harmonization across different topics. And so again, you'll see a lot of those issues reflected in the recommendations from ACUS. So I'm happy to participate in this meeting. I'm happy to answer any questions that people have about the report, and thank you for giving me the opportunity.
Thank you. Thank you, Professor Cohen. All right. Well, let's get our discussion underway. Perhaps we'll begin where the professor left off and generously agreeing to answer any questions. Is there anyone who'd like to start us off with some questions for Professor Cohen? All right, seeing none.
Allison,
Yes,
I think we've
please.
got a few in the queue. I think Randy
Okay.
May, Eloise Pazikov, and Rob Girard.
Oh, great. For some reason, I'm not able to see that. So if you would, I'd be grateful for your assistance in.
Allison,
calling.
I'll take care of that going
Thank
forward.
you. Thank you.
So Randy May has his arm raised.
Okay, I finally learned how to do that after about three months of Zoom. Hello, everyone, and George, thanks for this. So this is really just a comment right at the very top, I guess not a question, but it's at the very top. When I looked at this, it struck me that the title says Regulation of Representatives and Agency Proceedings, and then it quickly became clear we're talking about adjudicatory or adjudicative proceedings, and there's such a difference. I mean, and it's limited to that. So I just want to suggest when we get to the right point that we add adjudicative in the title, and I think that will be helpful right from the get-go. I can't hear George. It looks like he's speaking, but.
Sorry, I'd be happy to do that. Thanks for the suggestion.
Okay.
That's a great suggestion. Thank you.
Thank you. I'm just looking at my screen, so this won't be in the order that your hand was raised. Eloise Pazikov is next.
Hi, everybody. Thanks. So I have one framing question and one research question. And my framing question is that I don't fully understand the problems that the study and recommendations are setting out to fix. And so it's making it a little hard for me to both understand where the analysis is going and also whether these are the right recommendations and are they the right recommendations? And so I would love a little more background on what are the problems we're trying to fix? Because I can imagine many different problems that would point in just different sorts of directions, from there aren't enough representatives to there's a lot of misconduct to there's differentially bad misconduct in different places to, just like a whole host of things. So I'd love more of a sense of what are the problems that that you as the consultant and then this committee as committee are tasked with fixing. So that's the framing question. And then the research question is, I was a little uncertain about the timing of sort of the speed with which we're moving through this project, considering the way your very careful report talks a number of times about the limitations of the data. And so I was wondering whether there would be an opportunity to talk to some of the folks who you identify quite rightly that you haven't yet spoken to. So whether it's observers or litigants, claimants, respondents, or representatives, and especially the non-lawyer representatives, which seem like they are given almost 50% of the, or like they're sort of equal billing in the recommendations, but I just don't have a sense really of where they fall in the universe. So that's my research question.
Great, thank you very much. So in terms of the first question, what are the problems? So the way I structured the research and the report was really to try to figure out, are there any problems? And so I was really kind of asking questions to get a sense of what's going on and what's the nature of the kinds of rules and how are they being implemented. And so and my view was that that's what I should report. And then from that, see if there are any things that might make sense to work on in terms of improvement. So I think I say in the report, and I believe that given the limitations of the study, I think it's hard to make very strong recommendations because I'm not getting a lot of information about the kinds of things that I think you think are important and I agree are important, such as, what are the real problems with the representation in general, what are the main issues that we're seeing, and what are the best ways to sort of address that. So I think going in, I thought I would get a lot more information about that question. And it turns out that there's not a lot of information about that question that I was getting from the interviews. And so I presented what I found from the interviews and the recommendations that I think might be based on what I found, which are more in the direction of, well, here's how one might improve on these rules in terms of clarification and publication. And I think that could benefit any number of people, from the participants in the agency, the ALJs, in being able to implement these rules, to the practitioners who are supposed to be guided by these rules, to the general public who would be interested in perhaps how do I file a complaint and what do I do about this? So I can't say there's a huge problem on any of these things. I'm just saying that the findings raise these issues for me, and these are ways that one might address some of these issues. So, but on the second point, I completely agree. I very much wish I had more time and more opportunity to interview more groups of people and get a fuller sense from different perspectives of, what is the perspective of the people who are actually represented by these people? What's the perspective of the practitioners who are subject to these rules? So this was obviously a very limited sample, and I agree. Before one would want to make really strong recommendations on some of these areas, it would be very helpful to hear from those groups.
Great, thank you. Erica Litzon's hand is next.
Thank you. So I to some extent, I'm repeating Eloise, but I wanted to go ahead and kind of do my question instead, or my comment really, which is that, well, it's two parts. One is the scope issue, and somebody already, Randy mentioned this about making it clear at the start that it was just about adjudication, but things that are adjudicative, not just formal adjudication, but that are adjudication rather than rulemaking, span a vast range across our many agencies. And I have a little bit of a sense that a broader research scope would help, because I think how we think about representatives helping in some of these proceedings at some of the agencies might be completely different from kind of the model that comes through from this paper. I'm just thinking of a lot of the kinds of things that are adjudicative that FDA does, which is the agency I know the best. And it feels like most of this just doesn't quite fit the kinds of representation and the kinds of people that are doing it. But the second thing I have is more along the lines of what Eloise said, which is I'm not persuaded there's a need for anything right now. I mean, aside from the very simple proposition, which I agree with, that transparency about the rules, if any, is ideal, and we should encourage it on websites and, if appropriate, in the CFR or the Federal Register at least. I don't see much of a need for anything else, especially before we know kind of the full range of what agencies do and what representatives are even doing before them and how they feel. But I'm left very, very cold by the notion that there is actually a virtue to uniformity, given the extreme variety of types of proceedings and agency interests. And I'm particularly not persuaded by the notion that agencies that deal with the same issues should have the same rules, because the kinds of proceedings could be fundamentally different, and the specific things they do could be completely different. So I left this thinking, it's not ready for prime time. We need to do more research. And at this point, I'm disinclined to support anything other than a transparency, recommendation of transparency. I think the report is fascinating. I loved it. I just that we need to know so much more. So it's not really a question. It's very academic. It's more of a comment than a question.
No, that's great. And I think that's very helpful. And you know, that's exactly, I mean, to me, that's the whole point of having this kind of group of people who know much more than I do about the various ways that the agencies do things. And, you know, I'm coming at it from a particular perspective, and that's why I want to get these kinds of feedback. And I assume ACUS wants to get this kind of feedback to really see, you know, is there really something that needs to be addressed here? So I viewed my job is as to kind of report on what I found, raise some questions about it, but I'm not coming in here with a strong banner of we must have uniformity on various topics. I think there are some reasons to think it might help, but you know, I think there are reasons to have variety as well. And if things are so different in terms of how the agencies operate that it just makes sense to have different rules, well, that's fine. But at least it's worth thinking about and discussing and exploring. And I agree that having more information would be helpful. Absolutely.
Great, thanks.
Thank you. Allison, I have 6 other hands raised. I'm going to just keep calling them down the line, but if you have anything to add or jump in with, please do so.
Thank you. Thank you, Gavin.
Robert Girard is next.
Sure, thank you. Like Randy May, my comment really stems from the title of the recommendation. It's clear that the report and the recommendation covers rulemaking and discipline by agency authorities that regulate enrollment to practice before the agency, as well as collateral issues like referral to and from state bar authorities. But it does not cover the authority of hearing officers to sanction representatives as an exercise of their authority to control hearings and pre-hearing proceedings, like the authority to sanction an agency or to sanction a representative for contumacious conduct through an adverse inference or by excluding the representative from a particular hearing. But since the title of the recommendation, Regulation of Representatives in Agency Proceedings, really suggests both types of authority, regulating enrollment to practice and controlling hearings, I think that if this title stays the same, at the very least, there should be language in the preamble clearly setting forth what this recommendation covers and what it doesn't.
Great. I will certainly do that. I want to be as clear as possible about what we're doing and what we're not doing. So I thank you for that.
Thank you, Robert. Jeff Lovers is next.
Thank you. Good morning. First of all, I think there's a wealth of information in this report, and it's really useful. I did want to point to one problem with the report, which is that it mentions that it sort of conflates the Agency Practice Act and the APA. On page 5, it talks about the APA has language about, you know, representation in agency proceedings, and that's really the Agency Practice Act. And I only mention that because you know, ACUS does have a source book on federal administrative procedure, which Bill Funk and I originally did for the ABA, and it does have a chapter on the Agency Practice Act and lists a lot of the rules that the agencies have. And I think this report, with all of its updated and extensive information, will be very helpful to ACUS in you know, freshening that chapter of the source book. But I also wanted to mention that there's a recommendation that ACUS did back in 1986 when I worked at ACUS called non-attorney assistance and representation. And it basically focused on the need for more non-lawyer representation in, I guess, what the recommendation called mass justice programs like Social Security, IRS, VA, and immigration proceedings. And it encouraged agencies to the extent that they could to maximize the participation of non-lawyer representatives. And it was based on a good report by Zona Hostetler, which talked about the needs for that. So I would hope that it's a very, very short recommendation and only had 4 paragraphs. But I would hope that if we are going to say something about non-lawyer representation in this recommendation, that we sort of incorporate some of the thoughts in that recommendation. And the last point I guess I'd say is that there is I know that when we did that recommendation, we talked extensively with the National Organization of Social Security Representatives, NOSCR, which is, the organization that sort of represents the non-lawyer representatives in Social Security. And, they have, I'm sure they would have a lot of thoughts on that point. And also, I do remember when we did the asylum recommendation, maybe 6 or 7 years ago, we got into a big discussion of whether the asylum officers and immigration judges, how much they could control their proceedings and whether they could engage in any kind of, contempt citations for misbehavior by attorneys. And I think there were some special rules relating to to those proceedings. So that's something else you might want to consider. Thank you.
Great, thank you very much. Those are great suggestions, and I will certainly fix the reference to the APA in the report, and I will take a look at the 1986 report, and I will try to incorporate those.
It's the other APA.
The other APA. Thank you. Yes. Well, this is what happens when you're not a specialist in administrative law, so I apologize for that.
Jeff, you'll note that the draft recommendation before the committee does cite the correct statute.
I did see that, yes.
Oh, thank you. Roxanne Rothschild is next.
Hi, I'm with the National Labor Relations Board, and I just wanted to comment in response to Eloise and Erica's questioning about what is the purpose being served by this topic. This is just our agency, but I just want to let you know that I think that our agency has a lot of problems in this regard. We have rules. We have rules for regulating conduct, but we have 2 fundamental problems with them, I believe, which is number one, we don't define what the inappropriate conduct is. And as a result, it has to take extremely egregious conduct before anyone will even try to do anything to regulate activities. And I would say that in the labor law arena, there are a lot of strong emotions in our hearings and our proceedings. And so restraining ourselves to only the very, very worst offenders is problematic. Also, we have some functional problems with the way our rules work. We have struggled at times as to how to even make it work out for us, just to say that. So I personally was thrilled when I heard that ACUS was taking on this topic, because we have tried our own efforts at trying to benchmark with other agencies and figure out how could we be doing this differently, what would be some better ways for us to approach this topic. So that's, I know that anecdotes are not data, but that's our experience.
Thanks very much. And that was a topic that did come out in the discussions with NLRB. So I think that is at least one consideration in terms of having more specific rules. I thought that was an interesting observation, that if you don't have specific rules, it leads potentially to the issue that an agency is only going to address the most egregious conduct, and so that's certainly something worth considering.
Thank you, Roxanne. We have 3 hands next, and after that, we may start with the discussion on the specific recommendations. Jack Bierman is next.
Thanks. I just wanted to be on the flip side of what Jeff Lover said. There is an APA section that actually is relevant, which is APA section 555, which talks about the fact that anyone summoned to an agency has a right to have an attorney represent them, and that it's up to agencies to decide whether to allow non-attorneys to represent them. So we might want to refer to that. And in fact, even like right at the opening of the research report where it says, agencies allow, I mean, sometimes they're required to allow. So I would cite APA, the other APA 555 somewhere And if I'm correct in my search that at this point, the research report doesn't cite it. It's not a big deal, but I think it's, important enough for the framing of this to mention it. And I can't remember if it was Eloise or someone else who took this same line, but when I read the report and then I read the recommendations, I felt like the recommendations were a little bit of overkill, at least my instinctive reaction. And maybe this belongs more in the discussion part, but it's an overarching comment. That it seemed to me that the report made a very good case for transparency and for maybe some information sharing, but it didn't seem to me to, given that there's no one is making big complaints, it didn't seem to me to make a very strong case yet for this big effort that agencies would have to undertake in order to meet the substantive parts of the recommendation, which were to promulgate, rules on attorney and representative conduct and misconduct. So, that's my instinctive reaction, and I'm obviously open to discussion on this, but I didn't see anything in the report that actually convinced me strongly that much more than that was needed at this stage.
Well, thanks very much for the suggestion about section 555. I actually did have something a little bit in there about that. There's some litigation that's currently going on about that, the application or the interpretation of that statute. And there was some question about whether I should include that in there because of the ongoing litigation, but I should probably put it in there anyway, just for reference purposes. So thank you for that. And then I'll leave the bigger point to the discussion, but I certainly think that that's a reasonable position to take, that the stronger recommendations are in the area of transparency and coordination, and harmonization is something that I think potentially has some benefits, but I'm not sure that the case has fully been made for a full-fledged effort in that direction.
Thank you, Jack. Next is Mark Stokojewski. Did I get that right?
Everyone. Hi. So a couple of things. First of all, as one of the things that I think that is very critical to consider is that not only are not agencies all alike, but their process is far different. So for example, SSA's hearings are non-adversarial. Hence the reason why we allow or encourage claimants, if they choose to have non-attorney representatives. Secondly, we changed over our code of standard of conduct for representatives a number of years ago, and we've made a lot of internal changes thereafter. So for example, very few cases rise to the level of an adversarial sanction hearing. And I am actually the liaison for the Chief Judge's Office with a very small core of management judges who hear those adversarial cases with representatives, as I do myself. And it is absolutely true that only the most egregious cases are conducted in that kind of a proceeding and will ultimately lead to sanction. But that's a very small part of the picture. Even within the last year itself, we have streamlined our internal process. And the last thing we ever want to do is actually sanction a representative. It's always better to advise them of the potential violation of the standards of conduct and get them to self-correct. So for example, we've nationalized the reporting process, and ALJs are encouraged to report concerns. Of course, they do not have contempt power or sanction power for individual cases as some other agencies do, but they can certainly report when they see an egregious aspect or more significantly, a pattern of concern. And that is reported through not only to a headquarters, to the Office of the Chief Judge, but also to the Office of General Counsel. And what we have found in many instances, a reminder letter from the regional chief judge to the representative, advising them of the concern, pointing out to the rule that they have not complied with, is usually enough to resolve the matter. And if that doesn't happen, the Office of General Counsel then takes over in a sense and sends a warning letter. And those warning letters are very effective because there are many Social Security representatives who exclusively practice before SSA. That's the bulk or certainly a significant part of their practice. And the last thing they want to do is lose the opportunity to do that. So if the reminder letter doesn't work, the warning letter from OGC does. And it's going to be a rare instance where we're going to have such a pattern that's not corrected short of not requiring a sanction hearing. So again, I think my main point is the agencies have different processes, and not everyone should have the same capacity for sanctioning based upon that. And secondly, far short of the disciplinary aspect, there are a lot of other remedies that very often work. For example, the Chief Judge's Office and others regularly appear and talk to NASCAR, and the communication is both ways. NASCAR and NADAR, that's the organization for non-attorney representatives who practice before SSA. And those communications, the representatives convey to us their concerns, which we look into, and vice versa. And sometimes they self-police their members as well. So I would say that from SSA's perspective, the change in the regulations with respect to the standards of conduct, the communication we've had on a local hearing level, regional level, and national level are very effective. And the fact that there's a very small number of cases that are reported in terms of sanctioning representatives is actually a good thing.
Great. Those are very helpful comments, and I certainly agree that the count of the actual number of disciplined practitioners is not the only thing that matters. Obviously, the better thing to do would be to have people comply with the rules, and I think part of the issue is what's the best way to do that, right? What's the best way to try to provide enough information both for the practitioners so that they can be guided sufficiently to adhere to the rules? What's the best way to provide information within the organization so that they can hear and deal with these complaints and try to communicate to people, what are the issues that you need to be particularly aware of. So I agree with all of that, and I think that's one of the benefits of having rules such as the SSA has that are pretty specific about what it is that they're concerned about. And so I think even agencies that don't have the same practice or the same structure as the SSA may still be able to benefit from those kinds of rules designed to match what their agency is doing for exactly those kinds of reasons, that we want to provide the right kind of information and guidance to people so that the whatever problems exist are minimized or dealt with before formal sanction needs to take place.
Thank you. Final hand is Jim Tozy.
Thank you. I would like to compliment the ACUS for choosing a non-expert in administrative law for writing a report. I think there's a tendency for all disciplines to become so self-insular that we lack some input from outside sources. And I'm not saying that's just this section. I deal a lot with the economics section, economists, and you very seldom see experts in microeconomics like benefit cost analysis address fiscal policy issues. And you very seldom see fiscal policy issues look at benefit cost analysis. In a tendency in the economic profession, we become very insular and self-perpetuating. And so first, I applaud having somebody not a member of the club write to report. The second thing that in there is that there is a lot of questions, as some speakers were very articulate, not answered. I saw this report as more as a catalyst to look, to examine, is there and how big is there an issue? And I do think there's an issue in this report, and I think Jeff Lubbers stated it. I think there's a tendency for the legal profession to make everything represented by lawyers. I'm a bias, I'm a non-lawyer, but I see that happening more and more in virtually, in fact, the government's becoming that way. How many heads of big agencies are all lawyers, whether they know anything about economics or anything else? It's that. And so I think that this report was a catalyst for looking at the non-lawyer participation in these services. Now, Jeff Lubbers said it, if you speak to a lot of people that call our center, we could not even come close to handling it. They just can't, there's a lot of people that have problems with the government. They just can't afford lawyers at anything. And I think the idea of opening this report opens that part of that discussion up. So I applaud the report as it's written. I think and I might have missed, I'm usually very sensitive to whether reports say you have to issue regulations. And if it's mandated in here, then I think that should be looked at. But probably when I read it late at night in my second glass of Barolo, I missed that. But I think it is a very good first step to open an issue that should be discussed by the public. Thank you.
Yeah, I agree. I mean, I think that in some sense, the agencies have been kind of ahead of the curve on this idea of access to justice, where you now are seeing some experimentation by several states in terms of opening up legal practice and in various ways to non-lawyers or adjudicative practice or other kinds of practices. So the fact that so many agencies at least have the ability or permit non-lawyer representation, I think is a good thing, and I think that is an important part of the thinking about this process. And that raises a whole bunch of questions about, okay, well, if you're going to allow these people to do it, what qualifications should they have? Should they be subject to the same rules as the attorney representatives? And if not, what are the meaningful differences? So I think all of those things are important topics, and the ability to provide greater access to representation for individuals in particular, I think is a very important issue to be addressed. It's not something I could fully deal with in the confines of this topic, but it's certainly part of it.
Thank you, Jim. There being no other additional hands at this time, I'll turn to Allison.
Sure, and I do have to say, Jim, I noticed that we've gotten you in our bad lawyer habit of actually using the term non-lawyer, which I think, if anything, sort of describes our insularity of focus sometimes.
Yeah,
Right?
I learned because I may want to take out law and pass the course, so I learned. Okay, yeah, we call you non-economists, right?
Touche.
Allison, may I just add something on this issue of non-lawyers? ACUS is, as some of the folks on the phone know, ACUS is one of, 20 or so presidentially appointed members of what's known as the Legal Aid Interagency Roundtable. Stephanie is nodding her head, and I think Jim Sandman, the former president of Legal Services Corp, is on the line as well. He's involved in that initiative. There's no question that ACUS will be, in the context of that roundtable and otherwise, addressing issues of non-lawyer representation. Jeff referred to a recommendation, I don't know if it was from the 1980s, on non-lawyer representation. ACUS has actually already issued a more recent recommendation on non-lawyer representation and making legal proceedings, adjudicative proceedings in particular at agencies, more accessible to non-lawyers through a variety of methods. And so while that's not within this, probably not within the scope of this project, that is something that no doubt ACUS will be giving additional consideration to, and it's very possible that ACUS could initiate a new recommendation project on that subject. So I just wanted to give that background.
Thank you, Matt. Before we head into discussing the specifics of the recommendations, Mr. Frisbee, if you would like, I'd like to offer you some time if you'd like to say a few words on behalf of the ABA. You're welcome to do so at this time.
Yes, thank you very much. Are you able to hear me?
Yes.
Okay, great. Thanks, everyone. I'm Lars Frisbee. I'm the ABA's Associate Governmental Affairs Director, which, as you know, is the largest attorney association in the U.S. and the largest voluntary association of attorneys in the world. Also attending today's meeting are my colleagues, Andrew Emery, who, as you know, is a member of ACUS and chair of our ABA section of Administrative Law and Regulatory Practice, and Ellen Rosen and Mary McDermott, who are with our ABA Center for Professional Responsibility, which is the part of the ABA with expertise on lawyer regulation issues and development of the ABA Model Rules of Professional Conduct. So we appreciate your inviting the ABA to attend today's hearing and giving us opportunity to share our thoughts on the draft report. I wanted to start off my brief comments with a short disclaimer that because the ABA Constitution and bylaws provide that only our president, the ABA president, or a person designated by our president is authorized to testify for or express the policy of the ABA, and no other member or employee of the ABA may represent it before a governmental body. And I guess this committee is sort of, in some ways, a governmental body. Our comments today are really informal and limited solely to sort of briefly explaining, the ABA's existing policy that is relevant to the development of this report and recommendations, and offer just a couple other brief non-policy comments. First of all, as Professor Cohen noted on page 3 of his draft report for ACUS, the ABA's most relevant policy on this subject was adopted way back in 1982, but it's still good ABA policy. And it was in response to a proposal for a set of model rules for agency discipline. And our resolution that we adopted through our House of Delegates supports legislation that would preclude federal agencies from adopting, quote, standards of practice to govern the professional conduct of attorneys who represent clients, end quote, that are subject to the agency's jurisdiction, other than those standards of practice, quote, affecting such attorneys' participation in a particular proceeding before it as immediately necessary to maintain order in or assure the integrity of such proceeding, close quote. In addition to that specific policy addressing this subject of rules of professional conduct by federal agencies affecting lawyers, the ABA has also adopted many policies in recent years stating that lawyers engaged in the practice of law should be regulated, overseen, and disciplined primarily, if not solely, by the state Supreme Courts that license them, and through lawyer disciplinary agencies overseen by those courts, not by Congress or by federal agencies. The ABA has also consistently opposed efforts by Congress and certain federal agencies to regulate attorneys in many specific situations. So we've actually filed lawsuits against the Federal Trade Commission, for example, several times when we thought that their regulations were too broad and improperly tried to regulate lawyers engaged in the practice of law, and received summary judgments enjoining those federal rules from applying to lawyers. All of these ABA policies, including the 1982 policy cited in the professor's report, are still enforced and remain the ABA's sort of general position in this area. Therefore, the ABA continues to oppose the adoption by federal agencies of standards of practice governing the professional conduct of lawyers, except when those standards are, quote, immediately necessary to maintain order in or assure the integrity of proceedings in which the attorneys are participating. And we believe that all other disciplinary matters should be handled by lawyer disciplinary agencies overseen by the state courts. Now, although the ABA continues to support judicial regulation, oversight, and discipline of lawyers and oppose federal agency standards of practice governing attorneys' professional conduct, so we recognize, of course, that many federal agencies have adopted such standards and they're a reality. And we also praised the draft report. We thought it was excellent and very well done, and had an enormous amount of useful information that I, after working on this for 20 years, was not aware of, and that it did an excellent job describing the various professional conduct rules that have been adopted by the various agencies referenced in the report, although the report acknowledged it was limited to a certain number of agencies that it studied. And we think that the information in the report will be a very valuable resource to ACUS and to the federal agencies, and would encourage you to disseminate it broadly once the report is finalized. At this time, based on that background and sort of what our policy is, and we're sort of governed by what our policy says, we don't have any specific comments on these proposed ACUS recommendations for the committee that was issued yesterday. But several of the other recommendations contained in the report that were not in the formal recommendations we thought were very useful. And I just thought I'd take just a second to highlight those couple of things. For example, in the coordination section of the report on page 41, it discussed the benefits of the ABA National Lawyer Regulatory Data Bank and encouraged all agencies with rules and practices on referral and reciprocal discipline, and perhaps all agencies with professional conduct rules, to participate in the ABA Data Bank, both to refer disciplined representatives and to check on the status of representatives before the agencies. So we think that's a great recommendation. And of course, we would welcome all federal agencies with any kind of standards like this to participate in the ABA Data Bank. We think that would be very useful thing that could be done right away. And so we would encourage that. Also, on page 40 of the report, under the page 40 and 41 of the report, under the information and transparency and the coordination sections, they both discussed ways that ACUS and the ABA Administrative Law and Regulatory Practice section could collect and publicize important cases and ethics opinions addressing agency representative practice generally, and/or could help facilitate greater coordination of the various federal agency rules and practices. So we think both of those ideas are certainly worthy of further consideration. But that wouldn't involve the ABA endorsing anything from a policy standpoint, but we think that our administrative law section obviously is very, works closely with ACUS, and has for many years, and has, many of the ABA experts on this, in this area. So we certainly would encourage greater collaboration between ACUS and our administrative law section in order to sort of follow up on those good ideas in the report as well. So anyway, those are just some of our initial thoughts. And, we thank you very much for reaching out to the ABA on this, and including us in the meeting. And although we're limited really in the specific comments we can make based on our existing policy, so we certainly appreciate being, included in the discussion. Thank you very much.
Thank you very much. And we appreciate your presence today and appreciate your input. So Gavin, should we go ahead and put the
Can everybody see the screen?
You make it a little larger?
Thank you. Yeah, that would be helpful. Great.
Is that better?
Yes.
Great.
So I think there was a suggestion earlier about making clearer in the title and other headers about the focus on adjudicatory systems.
This is Randy May.
Yes.
I think in the title, it should say agency adjudicative proceedings, just to mirror what's right in the first line of the report. I know that various, within the context of adjudications, I know we're probably going to talk about a spectrum. There is a spectrum that we might be talked about, but I think my understanding is that nevertheless, we're still going to be focusing in this report on proceedings that fall in that category, except potentially with only minor or rare exceptions.
Allison, Jim Tozy has his hand raised.
All right, thank you, Gavin. Jim?
You're on mute.
Sorry, I just had a brief statement. I don't want to interrupt the cleaning up this. It was just that somebody, an earlier earlier speaker said they didn't see a lot of need in the report for this study. I think the testimony of the ABA should be exhibit 1 of why you need this report. They have that authority to enforce all this only because they have state licensing monopoly, which maybe you could look at a later time. That's all I had, so you can proceed with markup.
Thank you, Tim. All right, should we move down to number 1?
Can I ask a point of clarification? Was this an
Yes,
amendment then? Okay.
Well, again, Gavin, could you just, I missed what you said. What did, I'm just.
So this was a change that was suggested. Was there any other thought or about this, or is this an amendment that the committee is agreeing to make?
Yeah, just one, I don't know if we need to get into this. We sort of have, I'm not opposed to this. In fact, it sounds like a good change, though. I'm not sure why it doesn't just say adjudications rather than proceedings, but Reeve, can you just Allison, if we may for a second, we sort of have special approaches to title changes. Reeve, can you address that briefly if you're there?
Sure. Yeah, happy to do so. So yeah, just sort of our past or sort of our protocol for title changes is the committee, if it's the consensus of the committee that they would like to recommend a title change. Technically, the title of the project is sort of set by the council, but the committee can recommend a title change. And I can't speak for, the council, but, I doubt that there would be an issue with that here. But technically, rather than making a formal amendment, the committee would be recommending an amendment, and then it would be voted on at the plenary session. It would be a recommendation, basically, to the Assembly of ACUS. And then, we would reflect that, and then it would be voted on at the plenary session. So if the committee wants to move that amendment, then, we can decide on it. And then we'll just put in a comment bubble reflecting, if indeed the committee agrees to it, that that's what they propose the title be.
This is Randy May. If you need a motion to move it, then I move we insert the word adjudicative there. And I'm just reflecting, I used that word to reflect the language in point number 1, just to be consistent there.
Is there
Councilman Wheeler has his hand raised.
Well, just picking up on Matt's point, since we're changing it, can you amend the motion to say representatives and agency adjudications?
I don't particularly care, whatever. I just wanted to get the sense of this being limited to adjudication. So whatever this committee or Allison or Carrie think is best is fine with me.
I agree with I personally don't welcome views of others, but I don't have any preferences between adjudications or adjudicative proceedings. Guess fewer words are usually better. So I think do we have in the nature of an amendment, I think, on the floor? Is that?
Jack Bierman is requesting.
Yeah, hi. I actually prefer adjudicative proceedings because I don't want there to be confusion about whether it's only about formal adjudications. So much of what agencies do, the vast majority of it is informal adjudication. So I think I would prefer the other words, but obviously that's up to the committee as a whole. Or adjudicatory proceedings, but adjudicative is better because, again, we don't want to have there be confusion that it doesn't apply to things that are not formal hearings. in my opinion.
Okay, well, this is Randy May. I say we go with adjudicative proceedings, and then we can get past the title here, and then ultimately the council, it sounds like it's going to make a decision in any event.
All right,
So
so I think we have a motion for this recommendation. Is there a second?
Second.
Okay, all in favor? Aye. Any,
Aye.
Aye.
any opposed?
Aye.
All right. Ayes have it. I think we'll make that recommendation to the council.
Or I guess technically to the assembly.
The assembly.
Yes, but
Yes.
yes.
Thank you. Thank you, Reeve. Thank you for that clarification.
And I would suggest also, I take it that this would be conforming changes elsewhere where proceedings not moderated by adjudicative would be put through the rest of the document, but that's worthy of further discussion. We could talk about it.
Thank you, Gavin. Okay. Number 1. Comments, discussion?
Anika Cooper has raised her hand.
I just, one question I had about the language about rules or standards. You know, the report focuses mostly on, you know, agency rules of practice. And I think many of the agencies that were mentioned in the report have, you know, they actually have rules in the CFR. Was there a particular reason why for the recommendation language we talk about, you know, having it be either a rule or a standard, which I suppose a standard would be something that might be more informal and just up on the agency's website? And if that's the case, you know, there might be some concern about whether standards that aren't, you know, in the CFR might have different, you know, sort of enforceability if you actually get into litigation related to that. So I guess my question is that deliberate to have that flexibility there, or is it just more of a rules and standards kind of mean the same thing?
I had read it as, you know, sort of one of the rare instances where or is sort of more in the nature of a conjunction, right? Rules or standards. I think we talk about rules or of professional conduct or standards of ethics.
Well, I guess one of the things, if you're going to get into, if this recommendation is going to get into discipline, and to the extent that that has an issue, you know, an impact on the adjudication, I mean, I think, you know, having them as rules is probably a better approach. But that said, if we want to leave the flexibility to agencies as to, you know, the degree of formality that they choose to sort of do this, that's fine. I just wanted to make sure that we were making a deliberate decision there.
Perhaps George could speak to that point about his findings about what these rules are called or standards.
Well, I think they're called different things, and sometimes they are referred to as rules of conduct or standards of conduct or rules of procedure. So my main concern there was that it would be nice to call them all the same thing, but I don't have a strong view about. I think it just depends on how this is generally understood in the agency world, you know, and if I mean, I would prefer rules myself. I like that term, but you know, if standards are understood by practitioners as meaning the same thing as Allison was suggesting, that's fine with me.
Jeff Lubbers.
I just note that after recommendation 2, we never mention standards again. We always just refer to rules. So unless there is a difference between a rule and a standard for this purpose, I think we should just go with rules.
I believe when these were drafted at the staff level, I think the intent was to be inclusive so as not to preclude any agency from thinking it doesn't apply because they have standards of conduct or it's a different thing. So I don't think by deleting it, it would have any impact.
It's also in number 2, and the preamble could explain that if you wanted to.
Allison, I see no other hands raised on this point. Oh, Jack Bierman.
Yeah, sorry. So I'm sort of a little bit stuck at whether there was some discussion about whether we wanted to even have number 1, you know, in the recommendations at all, or whether this should be pitched. I mean, I could see value in having guidelines about if agencies are going to do this, here's what they ought to do, because I think number 2 makes a lot of sense, and the considerations in number 3 and 4 make a lot of sense, but I'm not sure we're in a consensus about whether we ought to be recommending that they have them at all. And so, you know, if we're not in a consensus about whether they have them at all, then I think maybe number 1 should be something like agencies may choose to adopt their own rules governing the conduct of representatives, or they may choose to incorporate by reference other rules, or they may choose not to have any specific rules at all and rely only on state disciplinary proceedings or something like that. I wasn't trying to draft actual language at this point. And then most of what we say are actually useful guidelines for agencies if they choose to do it. But I think the committee has to come to some consensus on whether we want to actually have that positive recommendation in number 1. I'm not sure what the answer is, but I think we need to answer it before we go forward that way.
Erica Litzen.
I just want to me too what he said, which is I agree. I don't think we have consensus on that. And one person that wasn't me raised the issue of how much work, you know, a positive recommendation that agencies need to go out and do this is calling for a lot of work in agencies where there really isn't a problem. I obviously it is a problem in some, but for others, this is just added work.
Allison, there's 3 other hands, and I'll just keep calling them, but please jump in whenever you'd like.
Thank you, Gavin.
Next, thank you, Erica. Next is Albert Len.
Hey, thanks, Gavin. Just to sort of a spin-off of that previous comment by Jack. I mean, I wonder if rules of conduct is either too narrow or only applies to some of this. Conduct seems to me to go to sort of the disciplinary part of it, but I mean, transparency and qualification, I think might actually fall outside of the concept of conduct, and there may be more consensus on that than there might be on, you know, the rules that sort of speak to what people are, whether attorneys or not, are doing before the agencies once they are there.
Thank you. Hi.
I just want to add my agreement that I don't think we have consensus yet on the committee about how much we think we want to push agencies to spend resources on this issue. Again, with my hat, thinking about implementation. However, as Roxanne noted, there are some agencies that will appreciate this. So again, I don't want to wordsmith this yet, because I think we should have a sort of robust conversation about it. But conceptually, I think we are saying to agencies, first, consider whether you need to adopt written rules, right, for the conduct and other aspects of representation in your proceedings. And then I think we can say issues that you may want to consider in deciding that are and some of the pieces in the report. And then the rest of the recommendations are really directed to agencies that have some rules but are looking for best practices if they are updating or refining them, again, in terms of, for example, NLRB, or are now considering adopting them. So again, with that, I see this as more of a comment bubble to this, but I think that's going to be important.
Roxanne.
I was simply going to say that I think number one does two things. Number one, it points out right up front and center that we're talking about both attorneys and non-attorney representatives. I know we mentioned it later on in the recommendations, but given that we've already had significant discussion of attorneys versus non-attorney representatives, it's nice that number one says that right up at the front. Secondly, I was actually going to make the same suggestion that Hy did, which is just put in the word consider adopting instead of more complex lingo. And then in terms of the heading of this section where it says adoption of rules of conduct, why not just take out of conduct? Because then it's parallel to what we do with the next heading, which is content of rules. Adoption of rules, content of rules. Those would be my quickie suggestions.
Thank you, Roxanne. Albert?
Just consistent with that, I wonder if we're keeping one, if we should strike the conduct of between governing and representatives. So which agencies should consider adopting rules governing representatives in adjudicative proceedings? I mean, it just gets to my question whether conduct really covers all of the stuff we're talking about. Great. But others may disagree.
Great. Allison, I'll make a suggestion that maybe we just allow the members to speak freely rather than me calling on them, so we can have a maybe more free-flowing conversation. Would that be okay?
That sounds wonderful.
Great. So Randy, you're next, and then others should feel free to jump in. Other members should feel free to jump in on this point. You're muted.
Sorry about that. I'm going to suggest in point one that we possibly add the word participation so that it would say governing the participation and conduct of the representatives, because some of the items that we are going to consider relate not to conduct as generally understood strictly, but just the ability to participate. And maybe that would take care of some of the discussion that we've been having about conduct.
I want to respond to that. I actually would think it's better to just say governing the representatives, because some of them also have to do with transparency. And I think we're most likely to have consensus on adopting rules and making them transparent than about the full scope of it. I guess I think shorter is better, and I'd rather not have conduct in the front. And that, I mean, that's me. Obviously, Randy and I have a different view on that, but I would go with Albert's somebody's suggestion, just say governing representatives, but differing views on this.
Hi, this is Marion Zobler from the NRC. If we just say governing the representative, could that be misconceived as saying more substantive than what really intended, which is sort of this idea that, decorum and that kind of thing. I just fear that it's maybe too broad.
Yeah, this is Alice from State Department. I agree with that. I think governing the participation of representatives in adjudicative would be better instead of just governing the representatives. Kind of split the difference of what has been said before.
I say though that the talking about the governing of participation sounds more like when they can participate and who can participate rather than ethics rules. I think we need to say something in here. The word conduct signals that we're talking about ethics rules. So I think we need to say something here signaling this is both about who, because I think there is some reference in some of the later recommendations about, agency rules about who can participate. We need to say something about that signals that this is about ethics in this first recommendation.
Yeah, I don't have a problem with conduct either. I just don't think governing representatives does it for me.
This is Jeff. I think I agree with Randy's initial suggestion, just participation and conduct. And I think that the transparency is what we're urging the agencies to do. It doesn't really, it's not part of the governing or of representatives. So I like participation and conduct. And if whatever we agree on in this sentence, I think we should put it back in the heading.
I agree.
Well, I like it is because, I mean, while sometimes there's a value in brevity, if this is the very first sentence in the whole report, if it's too short, people don't know what in the heck we're talking about here, what it's all going to be about. Maybe there's consensus for this, Gavin. I don't know how or Allison, how you're proceeding at this point.
Well, I withdraw my suggestion. You guys have persuaded me. As long as it's should consider, I'm okay with it.
And Gavin, to make sure we get it reflected correctly, the title should be Adoption of Rules Governing Participation and Conduct or something to that effect. Is that fairly reflect the proposal on the table? So Gavin, do you want to
put conduct back in?
Put conduct back in, yeah.
I did want to raise, perhaps for further discussion, or maybe just a question, in light of the concern about consensus toward urging agencies to adopt rules governing participation and conduct, whether the addition of should consider is sufficient to address that concern, or do we want to have more discussion about? Because I do think there's sort of two concepts kind of rattling around in number one, which is the should consider, but then most of the rest of what follows sort of assumes that that's been done, and then just addresses what's been done and makes recommendations as to that. So I just wanted to raise for further discussion as needed, whether the addition of consider addresses those concerns, or whether we need to discuss more in terms of just number one at all.
I think, Allison, I think you hit this one on the head, given the prior discussion. My own view is that simply adding should consider it doesn't address the issue that has been raised. It's not really a resolution of the question that's been raised.
And this is high, as someone who addressed this, what I was thinking then is a next sort of, and again, not exactly sure the best way to do it, but to say you should consider adopting these rules governing participation and conduct. And then we explain in the preamble, things that you might want to look at to consider. And then if the agency and this is really a two, if the agency decides to adopt such rules, the following recommendations provides best practices for doing so, or provides options and best practices for doing so.
Would you just start that recommendation with the phrasing that if agencies choose to do this, then that follows? What my only concern is, and maybe I'm misunderstanding you, is that if it's going to list factors that if the preamble is going to list factors that agencies should consider in deciding whether to promulgate rules, those factors should probably appear in the recommendation itself and not just be relegated to the preamble. If it's not going to list factors, then it could just say along the lines of what you said, if agencies choose to do this, they should proceed as follows.
Yeah, my thought had been the former when I first talked, to include those factors, right? You know, consider adopting rules if they would advance. And the truth is, I feel you have them in number 7, if they would advance the fairness, integrity, and efficiency of the adjudicative process proceedings, right? That's your first thing. Are they going to advance fairness, integrity, and efficiency? There might actually be other factors, actually, in terms of a conversation, what we think. Then, if you've decided to adopt the rules based on those factors, read on.
Further thoughts, questions, comments on that approach?
So it sounds like High's recommendation might be more to combine 1 and 2 together, perhaps. Adjudicative proceedings, comma, if they will promote fairness, integrity, and efficiency of the adjudicative proceedings. Or someone may have better language, but that's what I was hearing, that 1 and 2 could be combined.
The only thing I would say is if we're going to do that in number 1, combine it with number 2, instead of if they will, we could say to promote, just say to promote the fairness, integrity, and efficiency of the adjudicative proceedings.
But I think the intent is to maintain that ability to have it as sort of an optional, truly a choice for the agency.
Okay, yeah.
Yeah, I was about to agree with you if they will, but actually I think it really is stop, look at this and consider. So if it will, or even if necessary to promote the fairness, integrity, but I think we can stick with if they will promote.
I would suggest adding, somehow in that agency's particular proceedings. Otherwise, it kind of looks like it's up. I mean, the recommendations and the contents, which we'll discuss later, those are recommended because we think that they'll promote, but we understand that individual agency proceedings, it may not actually meet that goal for that particular agency.
Yes, I would definitely endorse that.
I just wanted to raise whether fairness, integrity, and efficiency are the only 3 values that we want to mention here. For example, accessibility of the proceedings might be important for people who, need representation. And since we're talking about rules governing non-attorney representatives. Maybe that's a value we should mention.
I like that. This is high. And that's the other thing I was thinking, that let's give some thought to whether these are the ones that we want to say, because we haven't really thought necessarily about what do we want them to think about when they think about what do we want agencies to think about. So what I would do is, for purposes of timing, stick with this for the moment, but I think it's worth sort of mulling, thinking if there's anything else, you know, especially as we go through the rest, and then come back to this before a final vote on the recommendation.
Okay, so before we move on from the adoption of rules to the content, any other thought and discussion, particularly around, I don't want to beat a dead horse, but it does seem like it's an important conceptual matter in terms of being prescriptive, being suggestive, how we want to lay this out. If there's anything more that folks want to contribute before we start going through the suggestions about best practices. All right, then let's move on to what's now 2, I think.
This is Jeff again. So I think we should remember that ACUS has a long recommendation on incorporation by reference in agency rules. And a lot of it was geared towards making sure that people could, you know, access the reference material. So I think at a minimum, the preamble needs to reference that recommendation. But we might want to look at the recommendation and see if there's anything more we want to say in this paragraph. It's a 2011 recommendation, I think.
Jeff, would this come into play as a practical matter, or are any of the rules of professional conduct that an agency might incorporate, including and especially the ABAs, are they not available to the public? I thought the ABA's rules are in fact available.
You're asking me? I don't know. They may be, but the recommendation did have some other points. You know, I mean, these rules might change, and the agency needs to, you know, keep up with the changes. And there are a lot of things that we said in that recommendation. It was a very long recommendation, but I think you're right that most of these recommendations, these rules would not be copyrighted material.
Yeah, I just Googled the ABA rules and I was able to pull them up.
Russell, do you have your hand raised? You're on mute.
I have my hand raised now on this particular point, and it's a more minor point. One, I would strike in drafting rules because it goes on to propose an option, whether they should adopt or draft. Just started off with agencies should consider. And then down on line 13, strike carefully, as if the default is carelessly. And also, it's a little unclear in line 12. Any modifications should be included. Modifications to what? I mean, in the course of the sentence. I guess it's referred to the ones that they adopt or incorporate. Might want to make that clear. Any modifications to adopted or incorporated rules.
It's recommendation 2011-5, just for your reference.
Also on line 10, I think there's, either way you look at it, the word from, I don't know what it's doing there. Adopt or incorporate by reference from rules. You just incorporate the rules. I think from may be it. Unless I'm reading it wrong, which is not out of the question.
This is Randy May. One suggestion that I have following up on what Jeff said is that we might want to just explicitly say in here, it would probably be, I think around line 11, that that all adopted or incorporated rules are available to the public. I mean, we could just add those words and that would take care of, or that would help alleviate a concern about the incorporated rules not being readily available. You'd say, yeah. Might be some other place to put that, but it's probably not a bad thing to say in this particular point.
I had a question, perhaps for Professor Cohen, which is, were there examples you found where agencies had explicitly incorporated by reference rules of professional conduct from state bars into their model standards of conduct? I guess I can think of examples where agencies may have modeled their rules on those, but I'm not aware of anywhere agencies have explicitly incorporated anything by reference. So I thought that would be helpful to know what your research indicated.
Yes, it does happen occasionally. So I'm just looking at my report. So for example, I think there are two agencies that actually incorporate the ABA model rules. One is the ATF and one is OSHRC. And then there are, I think the Postal Regulatory Commission incorporates the DC rules of professional conduct. And then there are, I think there's one more that incorporates, I think it's the USDA in one of its rules incorporates the rules of the District Court for the District of Columbia, which essentially is incorporating the DC bar ethics rules.
We actually have a proposed rule for consideration in the Federal Register where we incorporate, or we propose to incorporate the ABA model rules, but only as far as practicable for the Federal Mine Safety and Health Review Commission. This is Michael Cole.
This is Albert. This question of incorporation, I'm sorry, maybe that I'm raising an issue that we've now passed, but is there any, do we need to consider the question of agency authority here to adopt these rules and how far they can go, or is that assumed? Has it been resolved? Do we need to at least flag it for the agencies to consider?
That's a good question. It sounds like a Professor Cohen question, possibly.
As I noted in the report, there are a couple of federal Court of Appeals cases that endorse the idea of agencies having the authority to adopt these rules, even if there isn't specific congressional authorization. All of those cases involve the SEC, but the reasoning seems more broad than that. But it's certainly an issue. I don't think the Supreme Court has weighed in on it. So it is a question.
Yeah, and you flagged a footnote, I noticed on it, suggesting that it was something of a debate. That being the case, I would think we should talk about whether we're just assuming that they have the authority, or whether we should flag that they should make sure that they do. I would be uncomfortable just assuming it without further discussion or understanding a little bit more.
Good. I have a question. I understood the person from the ABA to say that they recommended that all these enforcement actions go through the organization and their attorneys. Is that correct? I was in the government for a long time, and if you came up and told me that some private organization was going to overrule my authority to take some corrective action, that's foreign to me. So could you educate me? Is that how I understood that, gentleman? Is that correct?
Yeah, this is Lars Frisbee from the ABA. That's not what we said. What we said was, and by the way, it's not the ABA rules that are used to discipline attorneys. It's the state Supreme Court rules that are adopted, which are largely based on the ABA model rules. Those are the only binding rules. So we wouldn't presume to have attorneys disciplined directly by our model rules. Our model rules are simply suggested forms for the state Supreme Courts to adopt. Our view is that with regard to lawyers' discipline when they're doing anything in connection with the practice of law, including appearing before federal agencies, that lawyer disciplinary matters ought to be handled by the state Supreme Courts, which create disciplinary committees within their state to enforce the state court rules, which in practice are largely based on the model rules of the ABA, but they're not obligated to adopt the ABA rules. They've just chosen to do that as their binding state rules.
But does that mean if I'm in a federal agency and I found some attorney or non-attorney acting up, that if I wanted to take an enforcement action, I had to go through the state groups? Is that answer that correct?
Well, our policy is that those matters ought to be determined by the state courts that license the lawyers. So that might involve, referring the matter to the state bar, which I understand from Professor Cohen's excellent report is done fairly regularly by many agencies, where if they find misconduct, they often refer them to the state bar disciplinary committees for discipline.
But that means that I sitting in a federal agency, that would be my first course of action, as opposed to me taking some direct action. I find that foreign. Well, I've been out of the government a long time. And
yeah, well,
I'm foreign to that.
The APA's position isn't that the agency should have no rules, but that they, as I mentioned, that they should be only those agency rules immediately necessary to maintain order in or assure the integrity of the proceedings. So, rules regarding, decorum and regarding, things that immediately go to maintain order or ensure the integrity of the proceedings. I mean, that's as detailed as our policy is, but our position is that we don't favor agencies having comprehensive sets of disciplinary rules to discipline attorneys who engage in misconduct in the proceedings. We think those ought to be determined by the state court disciplinary bodies, perhaps through a referral. And so one of our concerns is that when the federal agencies adopt their own disciplinary rules, inevitably, they'll conflict in some ways with the with the binding state court rules, that the lawyers are already obligated under, and that the courts and their disciplinary agencies are in a better position to weigh the various considerations involving client confidentiality and other legal ethics rules than the federal agencies are.
Thank you.
Can I ask a question? And this is partly to the ABA representative, and I think, and would it be consistent with the ABA recommendation for the agency to say, you may not participate any longer in this particular proceeding, you may not participate any longer in proceedings, or you need to take a cooler for a year, but otherwise refer it to the state bar for investigation as to whether there was any ethical violation? Would that be consistent? When you say taking steps that are necessary to protect what the agency is doing. That would be consistent with it, would it not? Or
Yeah, two of my other colleagues who have more expertise on these issues than I do are hopefully still on the call. Ellen Rosen and Mary McDermott, who staff our ethics committee and our ABA standing. Ellen staffs our ABA standing committee on professional regulation, and Mary McDermott staffs our ABA standing committee on ethics and professional responsibility. Ellen or Mary, could you just briefly weigh in on sort of how that works within the ABA's lawyer regulation system?
May I just supplement Erica's question, because I think it is a key question. What exactly are we talking about when we're talking about discipline here? So I mean, it can't be that only a state bar licensing authority can discipline someone. A federal court can, in some manner, depending on how you use the word discipline a lawyer. The judge might disqualify a lawyer for having a conflict of interest, or take some other sanction or impose some other discipline, if you will, for being dishonest with the tribunal or something. So it might be helpful to clarify exactly what the ABA's position is and what we're talking about. Because it can't be literally true, unless you're talking about discipline in a very narrow sense, that only a state Supreme Court or state licensing authority can discipline a lawyer. I mean, federal courts do it all the time.
May I, Madam Chair, may I jump in?
Yes, please.
Thank you. As Larson mentioned, I'm Ellen Rosen. I'm the Regulation and Global Initiatives Counsel at the Center for Professional Responsibility, joined by my colleague, Mary McDermott, who's the Ethics Counsel. To Matt's question first, because I think it will relate back to the other question. When we talk about discipline, we are talking about violations of rules of professional conduct. So when we talk about lawyer discipline, we're talking about violations of rules of professional conduct. Whereas when we're talking about, for example, a judge taking an action against a lawyer in the context that you mentioned, Matt, I might refer to that as a sanction as opposed to discipline. I think that sometimes helps make the distinction more clear. I mean, certainly it could be considered disciplinary in nature. But I think that, for example, Rule 11 sanctions or disqualification may be considered a sanction as opposed to discipline. So when we talk at the ABA level about lawyer discipline, we're referring specifically to areas where someone has been found to violate a rule of professional conduct, and the disciplinary sanction is based on that violation. So it's a sanction that affects the lawyer's license or authorization to practice, for example, before a court or an agency. Does that help clarify before I go on?
Yeah, can I ask you a question? You just said ability to practice before an agency. So is the position then that only the state bar should be able to say, you, Erica Litzen, cannot represent before the FEC anymore, or can the FEC say we don't want Erica Litzen?
So that's what I was getting to next. But first, I want to make sure we're clear on that's okay on terminology. I just want to make sure that what I've clarified on terminology makes sense to everybody before I get to that other piece regarding our policy. Good? Okay. So the 1982 policy that Larson explained asked that Congress enact legislation. And my understanding is there has been no legislation enacted, and that since that time, a significant number of agencies have, of course, adopted their own professional conduct rules, separate from, in some cases, rules that would be more akin to trial conduct, if you will. And so, while the ABA policy is still good policy, and the preference there is to then have that defer, if there is a complaint of a violation of a rule of professional conduct, to have the state agency. I think it's important to note that my guess is back when that recommendation was made, and Larson can confirm this, one of the other reasons in addition to our policy favoring primary state-based regulation, was a resource issue. And this came up in another context with regard to a different set of model federal rules that relate to courts, where for resource purposes, the recommendation was that courts rely on the state agencies as the kind of investigator and prosecutor of misconduct of first instance. And then when there was that finding and discipline at the state level, the federal court could take a reciprocal action. So I think we're kind of stuck in an interesting place where we have this 1982 policy, but we also have federal agencies, a significant number of them, that already have in place rules of professional conduct and disciplinary mechanisms. And I know that the ABA has worked with a number of those agencies when they have issued proposals through the CFR to amend those. For example, we've worked with the USPTO, we've worked with the Veterans Affairs Administration. So I think it's given the state of the policy, while the preference may be that, I think we have to acknowledge the reality that agencies are already and have been doing this for some time. And I don't know if that helps you, but I hope it did.
Does that mean it? And the answer to her question is yes, that FDA could put the rope to somebody if they didn't like them and they misbehaved?
I'm not sure I understand your question.
I thought Ms. Litson said that if I were an FDA and there was an attorney there that acted in a way that I didn't think appropriate, whether the FDA could take some action against that attorney for a variety of things. And I thought that was her question.
Yeah, my question was whether the agency could, whether we call it discipline or sanction,
Right.
and I understand the difference in meaning that the ABA is using, is saying person so-and-so may no longer practice before the agency. Is that's considered discipline according to the first thing you said? So that would be, the ABA's position would be then that the agency can't do that, that should be done by the bar.
That's my question.
Well, we're not saying that they can't, do it legally. We're just saying that we don't necessarily support it.
Right, yeah, okay, shouldn't.
Yeah, they of course have the power. They of course have the power to do that, but we don't support it. We think that the courts ought to be the primary regulator of attorneys, and of course, we don't always win that argument. But in many instances, we've been successful in, persuading agencies not to adopt their own particular rules of practice that conflict. I know that a number of years ago, I worked with our ABA task force on corporate responsibility after the Enron scandal, and the SEC was contemplating adopting their own rule of conduct where they would require lawyers that learned of client misconduct to report the misconduct up the corporate ladder, and if it didn't cease, even after it went to the board of directors within the company, the proposed SEC rule would have required the lawyer to do a noisy withdrawal and basically notify the world they thought their client was engaging in misconduct. And we persuaded them to not go forward with that because the ABA already had extensive ethical rules in place, and they agreed to not pursue that. So that's just one example where the agencies often have the legal power to do it, but we don't necessarily support the choices that the agencies might make to adopt those positions.
And I think you have to consider too that the policy we're looking at here and what Larson is talking about is if we're dealing with a blank slate. But in the case of my understanding is the FDA, those rules are already in place. So I would agree with what Larson said, but also, to say that we would recommend you not do that. This took place about 40 years ago, and we were dealing with more of a blank slate, I think, at the time.
And I don't want to get lost, and maybe this is in the nature of a comment bubble, and we do this, I think, I would certainly appreciate a 5-minute break, and then we'll come back and go through the content. But Albert's very good point, I thought, about agency authority, setting aside that agencies already are doing this. I just don't want to get lost in the discussion, Albert's point, because I think it also directly bears on what we've been talking about in point 1 about, should this be should consider, and if there's a question about agency authority, I think I didn't want that to get lost.
Can I
In the
just make a quick
discussion, because I
comment?
thought it was an important point.
Allison, can I just make a quick comment before we break, because
Yeah.
I'm going to have to leave at 12. But since I just heard the ABA representatives say that the 1982 House of Delegates resolution, I guess, is still the ABA's policy. The ACUS did commission a study of this whole issue of whether the government had the authority to discipline or sanction attorneys. And it was published a report by Michael Cox, and it was written shortly after the ABA took those positions. So it really goes into the pros and cons and the of the ABA's position and those who advocate for more government regulation of attorneys. But it's a very well-researched report. It's of course a little bit dated now, but so is the ABA policy, I guess. But anyway, I recommend that it's published on the ACUS website. ACUS only issued a statement after that report. They didn't issue a recommendation. And the statement was very non-committal and basically saying that they didn't think that there was any reason for Congress to establish some kind of uniform statutory provision on this. But if you want to get into the ins and outs of this issue, the Michael Cox report does a good job of that.
Thank you, Jeff.
Sorry, I have to go.
All right, appreciate it. All right, well, let's just take about a 5-minute break, and then we'll reconvene to continue going down the discussion of the content of rules. Ready to proceed? Thank you. All right, before we move on to the topics to consider in what's now 3, any further comments or discussion of 2? All right, this is more in the nature of just a member of the committee than the co-chair. I see that 3 refers to topics agencies may wish to consider in their attorney conduct rules. Is that intended? Are we talking about representatives, attorney and non-attorney representatives there? Or are we talking about attorney conduct rules? I assumed we were talking about representatives, but I just wanted to flag
We
that.
could probably delete attorney conduct and just wish to
Just say-
consider in their rules.
Yeah, just speaking on behalf of the ACUS staff in terms of the draft. So we put attorney in there because they're mostly applicable to attorneys, but we sort of flagged it as a point of discussion for the committee.
Okay.
Do we want to limit it to attorneys, or do we want to expand it to all representatives?
Thank you. Thanks for that. Is it possible to scroll on down so we can get the whole?
Sure, yeah.
I think that'd be helpful just to have the whole list. Yeah. And we did have some staff comments in terms of particular items particular questions about including these things.
Russell, you can go ahead.
It's a general question, which struck me when I read it, of whether these refer to conduct in the course of some particular adjudication, such as candor towards the tribunal, or whether they are more general and attempt to police representatives who, for example, commit a criminal act, not necessarily in the course of, while they're representing someone, but just, rob a bank at some point. and I don't know if I'm missing something or whether or not I'm misreading it, but they seem to be of distinct types, and perhaps those who prepared them could enlighten me. I mean, is it disruptive conduct all the time, or is it in the course of a particular adjudication?
Speaking for the drafting on the staff level, I would say that I think it was contemplated that this all be in connection with adjudicative proceedings. And the title and the previous recommend paragraphs now discuss that these are rules relating to adjudicative proceedings. And I think it would be inherent or understood that is also what this is contemplating in terms of the topics. So commission of a criminal act in the course of one's representation of another in an agency adjudicative proceeding.
So so a criminal act that doesn't happen during that is okay?
I would never endorse such a criminal act, but I don't believe that we were intending that the rules of conduct for agency representation would necessarily disagree with that.
Well, if everybody's happy with it, I'm not going to persist, but it might be worse. If anybody else had the reaction I did, it perhaps could stand for some clarifying language. I'm not sure what to suggest, but I took some while pondering just exactly how this worked.
I was unclear about it as well, in part because obviously when the bar itself takes action against an attorney, they're looking at a wide range of a person's behavior and not just actions within the course of representation. So those of us who come to it having thought about our own sort of character and fitness and bar regulation, I think it's reasonable to wonder what the intended scope is here. I had a question also about this list. I had the strong sense that this echoed what you guys found and what Professor Cohen in particular found in the rules that he actually reviewed, because there's a list in the report of sort of the things that were seen, and most or all of them are now listed here. And I wondered whether it would be a good idea for us also, especially given the limited scope of the surveying that was done, to think not just sort of what did we see, but also what would be a good idea. In other words, not to just limit ourselves to the kind of the things that were addressed by the agencies that were surveyed, but sort of what we recommend more broadly, just sort of to have that discussion, unless all we saw is what we recommend.
Professor Cohen, I think it would be helpful. Professor Cohen, would you like to weigh in at this point on this question?
Sure. On the question of are there other topics that are covered, the answer is yes. And what I had suggested in the report is we might start with the group of topics that seem to be covered by the greatest number of agencies, but there are a number of other topics that may be worth considering that are covered by a smaller number of agencies. And so I did not mean to suggest we shouldn't consider them in my report. I just suggested as a starting point, you might start with the ones that are most common. So it was not meant to be exclusive of consideration of other rules. With respect to the question about the crime issue, I was just looking through some of my notes on the rules on that. So there's a difference of kind of view of that, and part of this is the issue kind of spills over into this topic of qualifications in the first instance and discipline of conduct in a particular proceeding. So I think most of these are about the latter, as Gavin was saying, but there are some references in some of the rules to other things. So for example, in the Social Security rule. The way they state it is a representative must not violate any section of the act for which a criminal or civil monetary penalty is prescribed. Period. It doesn't say he must not violate the act in the proceeding. It just says if you violate the Social Security Act in any way, that can affect your continued participation in an agency proceeding. The Homeland Security rule says it's even broader. It says someone who's been found guilty of or pleaded guilty or nolo contendere to a serious crime can be excluded. So it's not limited, the way I read it, to something criminal that happens in a particular proceeding. So that particular rule may be unusual in that respect, but I just wanted to point that out, that I did find some rules that exist that seem to go beyond the particular proceeding, at least with respect to that topic.
So if it's not obvious, and to Russell's point, it wasn't clear, perhaps one possible solution would be to modify conduct rules, or to expand that to make it clear that, at least as they're contemplated by the committee, to be attached to adjudicative representation in adjudicative proceedings. But Russell, did you have a point?
Well, especially if what Professor Cohen said, even more so, and this may not be the place to do it, perhaps on rewrite, language that at least calls to the agency's attention that there are, in a sense, two different kinds of conduct that we're concerned about. Some that are proceeding specific and some that are not. And as I say, I don't have it in my head how to write it right now, but it seems to me, just what I've heard, that some clarification might be helpful. I mean, maybe there's two categories.
Because surely some of these are clearly just limited to things that happen with respect to a particular proceeding, like ex parte contacts. That's obviously specific to a proceeding, because one might, or just
standard towards the tribunal.
On the flip side, you could do something like, say, commission of a criminal act, whether in the course of the proceeding, or don't start typing it. I'm not giving you language. I'm just suggesting that you could break this list up into things that are specific to the proceeding and things that aren't, or you could clarify that one of the things the agency should think about is whether to look at conduct outside the context of the specific proceeding.
I'm sorry to raise the point without having suggested alternative language, but I wasn't sure whether I was just missing something, but I guess a few others anyway have had the same concern I do. And I don't know, is it proper to suggest that ask the drafters to prepare something that, obviously we're not going to finish this today, to look at it in a redraft?
Certainly, and we're glad to do so. I would ask maybe the antecedent question, which is, does the committee anticipate these topics to be applicable to activity that is outside a particular proceeding? Or did the committee want to limit these recommendations, or this paragraph at least, to those that are particularly in connection with an adjudicative proceeding?
Well, that's the real conundrum, isn't it? I mean, you don't want to say it's okay to use my example before, it's okay to rob a bank. Just don't do it if you happen to be representing somebody. You obviously don't mean that. On the other hand, you're not going to, I don't think you're talking about an agency undertaking a kind of a broad police surveillance that we're going to be constantly monitoring representatives who may not show up here very often, but might have potential conflicts of interest, and going to nail them whenever we find one, even though they haven't represented anybody for the last 6 months. I mean, I really don't know. I don't know how. I'm pretty good at suggesting we ought to draft something. I'm not so good at suggesting what it should say, but I do think it has to be clarified one way or the other.
Yeah, I can give a specific agency example that would concern me. So if we're in a proceeding and a non-lawyer representative has committed violations of the same act that they're now trying to represent another licensee for, we would have concerns about having that person representing another licensee when they themselves have been violating the act. Even so, it's not, their conduct of violating agency rules may not have anything to do with that current proceeding, but just the fact that it's the same act would be problematic.
I think we have a bit of an issue because I thought at the beginning we were suggesting that we're focusing on the conduct of agency representatives in a particular proceeding, and that's sort of, I thought, been the focus. But now we're talking more broadly about whether or not someone is overall authorized to participate before the agency itself in any proceeding, it seems, because if you're concerned about criminal actions or other disqualifying matters for an agency representative overall, it seems like we're maybe going beyond the scope of what I thought we were focusing on in the recommendation. Or at the very least, we should maybe have two parts that people suggested where we distinguish between matters where we're focusing on conduct in a specific representation and then sort of more broad qualifications for appearing before the agency, like criminal conduct or things like that, which I'm not sure if are the focus here.
Yeah, I agree. I always saw this as sort of conduct in the particular proceeding, and that's why it justifies, the prior goals, which is, efficiency of proceedings. And again, thinking from some of the NRC proceedings that we've had situations where, someone refuses to follow the rules, and then our rules actually give our administrative judges authority to take action to control their proceeding. I can think of one occasion when there was one lawyer who had a history, and to the point where they put some higher bar to get this person. I don't know exactly the case, but usually it's focused on the conduct of the individual proceeding. And we don't want to be going outside our area of expertise, because then you'd have to have a group of lawyers who are just going to be policing that. And I mean, again, for my agency, it's just not something that we see that often.
So the question is how to write language that cabins the areas of concern, cabins them, as you said, without seeming to indicate that clearly objectionable conduct, illegal conduct is okay. Somebody can stay on the rolls if they commit clearly unacceptable conduct, as long as they don't do it in the course of representing someone. That's a difficult thing to write. I admit. I mean, if you like, I could take a stab at it just because I raised the problem. I'd be happy to do that and circulate it if that would help at all. I'm not sure it'd be any better than what we have now, but I'll try it.
We would welcome your language if the need to move on is presented right now. Allison, I defer to
Yes,
you.
I think that would be helpful.
Okay.
Thank you, Russell.
Thank you, Russell.
Don't thank me until you've seen it.
A for effort.
Great.
So just quickly focusing on the list of topics here, are there any that raise concerns for their inclusion, or does anything come to mind that's not on this list that should be on it? I know that the staff flagged conflicts of interest and attempts to violate conduct rules, or knowingly assisting others in violating conduct rules, as specific ones to discuss whether they should or should not be included, but there may be others.
Well, my sense is that as long as it's, because hearing from other people, again, for some agencies, considering conflict of interest may be appropriate. Other agencies, it's like, it's not a concern. As long as it's a suggestion, I don't personally think, I think the list is fine.
Okay.
I had a question about conflicts of interest as well. I saw in the report, I guess, that some agencies have specific rules restricting parties from representing a representative from representing 2 or more parties in the same adjudication, which certainly makes sense because there may be a conflict of interest there. When I read this, I thought of sort of the sort of government ethics conflict of interest rules that say that an agency, say that, sometimes restrict folks who've worked at an agency from coming back and appearing before the agency for a couple of years. So I don't know if we need to clarify that, or if we think of conflict of interest as more of a, are you qualified to participate versus are you engaging in problematic conduct? I think of it sort of more on the qualification to participate side rather than sort of a conduct that occurs in the tribunal. But I guess I'm still construing what I thought was the sort of more narrow focus of the recommendation.
Any other thoughts on that point?
All right. So with the understanding that we will await the suggested language from Russell, should we move on to new 4? I think this may implicate some of the concerns expressed otherwise, earlier about being prescriptive and imposing burdens. So I'd be particularly interested in, they're still on, the speakers who had those concerns and how this paragraph strikes them in light of some of those concerns.
This is Albert. Erica, I think, is gone, but sort of channeling her. I wonder if this is too prescriptive in light of the potential differences between agencies and, what the various proceedings that they have, and whether it even, whether, I think the way she put it is whether uniformity is really a value that there's consensus is important here. And I'm not sure the answer to that question.
Professor Cohen, would you like to weigh in here just in terms of sort of your findings and the diversity that you found as you looked into this among even the relatively limited sample size that you looked at?
Sure. So, I think it's a difficult question. I'm not sure that I have enough data that could really help inform it in a sufficient way. But and some of the things that I said in the report are kind of speculations that I think would benefit from the experience and expertise of the people who are in this area. But what I was thinking in terms of the divergence is that there are some benefits to having some degree of uniformity. I mean, the fact that the ABA promulgates model rules that are then kind of adopted by the states with some variations suggests that there's some value in professional conduct rules to some degree of uniformity. But I recognize, of course, that the agencies have very different missions. They have very different proceedings. They differ in a lot of ways, and that is reflected to some degree in the way they have different rules. My question was just, or my point was just to raise the question: is this diversity beneficial? Is it really reflective of just the different cultures or the practices or purposes of the agencies, or might there be some benefits of some kind of harmonization, at least in some directions? And I was thinking about the possibility of, as I mentioned in the report, things like if you wanted to have, let's say, ALJs move about from one agency to another, it would be easier for them to have a consistent set of rules to sort of be guided by. If there are lawyers or other non-attorney practitioners who practice before multiple agencies, it might be better for them to have some consistency across their practice area. So how often that happens and how important that is, I think is certainly a question. I think there's also a question about just in terms of getting guidance, the way that lawyers would look to the law of other jurisdictions. If their particular jurisdiction doesn't have a rule on it, it would be helpful to be able to look at, well, what happens in other agencies with respect to similar conduct, even if that hasn't really shown up in this particular agency up to this point. So those are some benefits. Whether they justify the cost and expense and the difficulty of trying to move in this direction, I think is a fair question to raise. But those are some of the things that I thought were at least worth discussing.
Can I suggest, in light of that, can I suggest something? We could pair it back to something a little bit closer to what Professor Cohen was just saying, which is agencies should consider whether divergence between rules governing different types of proceedings is, necessary or beneficial, or you pick your word. Although that then raises a second question in my mind, which is, what do we mean by different types of proceedings? I mean, if this guidance here is aimed at adjudicative proceedings, and I think sort of consciously so, right, trying to avoid weighing in on informal rulemakings and other things, query whether we should be sort of wading into that, even in a, as a factor to consider type recommendation.
Others on that point?
I think that was a good point, that this is about adjudicatory proceedings, so it may be worth inserting that word.
Different types of adjudicative
proceedings.
If Albert's language is, as he had proposed it, is adopted or agreed on, I think we would need to change the second sentence to be maybe in more agreement with that. But maybe not.
I'm not sure you have to, but you could.
Yeah, I think it's okay. It does say may.
Yeah, exactly. Right. Sorry, so I had sort of interrupted my own self in suggesting a change. I think in that first sentence, you're going to need to strike the word "that" between proceedings and would. But that does make it more of a consideration and less of a prescriptive command.
And sort of in that same spirit, and this is more as a member of the committee than as a co-chair, I feel like there's sort of two concepts rattling around in this one concept is simply agencies considering sort of looking at what other agencies are doing from a best practices point of view, and agencies looking at what other agencies are doing from a kind of harmonization point of view, which is different. And it's not clear to, at some points in this, we seem to be talking about kind of agencies harmonizing within their proceedings and agencies as kind of different agencies harmonizing with each other, which seems a bigger project. It's kind of signaled with, it may also entail harmonizing rules across agencies, especially in cases in which the same representatives commonly appear. Just want to make sure we're keeping the sort of spirit of considering as opposed to being prescriptive here.
Could I just say one thing in response to that?
Please, please.
Yeah, so I mean, one, I mentioned this in the report. So there is one example that I'm aware of a group of agencies, and this is in the financial area, such as the Federal Reserve and the Controller of the Currency and the FDIC and some of those, what I call financial agencies, decided to adopt a kind of common set of what they call rules of procedure and practice. And so that's just another example. It may be worth just, unfortunately, I didn't get a chance to interview any of those agencies, but that's an example of at least some group of agencies dealing with some similar topics decided it was beneficial to adopt a uniform set of rules for those agencies. Now, it would be nice to talk to them and get a sense of whether they think that turned out to be a good idea or whether it was not really worth it or it wasn't worth the trouble to do it. But I just throw that out there as another example of something that's been done.
I mean, one, if the worry is that this is going to entail, especially for this last sentence, significant resources, we could preface it with saying something like agencies may consider whether to harmonize rules as one suggestion.
Yes, that would address my concern about seeming more prescriptive there than at the beginning, now that we've had the consider whether.
That's as it appears at the last sentence. I mean,
Yeah,
it's
you may
possible.
want to, sorry, you may want to add agencies may also consider whether to harmonize rules across agencies. Yep, I like that. And you may want to add in also, an agency may also consider whether to harmonize rules across agencies, just to make clear that we're talking about a different inquiry. Okay. Anything else on that graph? Okay, should we move on? All right. Qualification. And I think here, just even that heading raises the issue that we've been talking about with respect to particular proceedings. There's the focus of a particular proceeding or practicing before an agency writ large. And again, it looks to me like most of these in this section are broad as opposed to focusing on adjudicative proceedings. Discussion of 5, 6, 7 qualification.
There's no inconsistency, is there, between this section and the section we talked about earlier on, this list of improper conduct. Qualifications is a sufficient term of art that people know we're talking about basically credentials as opposed to characteristics. I think it's pretty obvious. I just raise it in case I'm missing something.
Well, it does, I think, sort of related to that is what's now point 7, qualification requirements for non-lawyer reps. It may just not be creative enough, but I'm not sure what we're thinking of. I mean, the things that would occur to me are things like conflict of interest, which were discussed above. So I think somebody had made a comment about how some of those things in that list felt like they were going to qualifications as opposed to conduct. I mean, I don't know that we're, I mean, to get to Russell's point about credentials, like, are we contemplating, educational requirements? I mean, that seems both perhaps, it does, I'm not sure it seems it's prudential or frankly wise. So if it's really just things like conflict of interest, then there may be some blurring between this section and the previous one.
Albert or Russell, might you have any specific language to help clarify these concerns?
I really, that's why I asked whether or not within this context, qualifications is a term of art that people know what it means and what it doesn't mean. I mean, represent a member in good standing, it seems that's a credential that you either are or you aren't, as opposed to having a conflict of interest. I may have raised an issue that doesn't deserve to be raised. I just asked the question whether others see any problem. There may be none there. And maybe
I think it's a good question.
Mm-hmm. Yes.
It wouldn't directly respond to it, but to take the point, item 7 could give some examples, and that would, in a sense, serve as an illustration of what qualifications mean. What would, if we said they should establish qualification requirements for non-lawyer representatives, such as, and then you by what you don't include, it's pretty clear you're talking about credentials. I mean, what would be the qualification requirements for non-lawyers? I don't recall from the report if they're listed, but what would an example be? have to have a BA degree, or you have to have demonstrated by some, specific means of familiarity with the area of law in question?
Well, if you want me to answer that, I mean, there are several different types of qualifications that the agencies do. So some qualifications, the agencies just limit the types of people or the types of non-attorney representatives who are allowed, right? So for some, like the SEC, you can only be a non-attorney representative if you're like an officer of a company or a partner in a partnership or something like that. So it's focused on the types of people who they're going to allow. So it's not focused on their qualifications in the sense of anything else other than that. But then there are some that do talk about, has to be a reputable person, or some talk about having knowledge of the agency's practices and things like that. So the VA is the big one, which has a kind of very formalized accreditation process, including CLE requirements and an exam that has to be taken and everything. So they're kind of on one end of the kinds of things that you would require. Part of it is also there's this kind of blurring, and it goes to some of the comments from before, between your question about what counts as a qualification and what's a disciplinary or a conduct rule, right? Because some of these things, a rule might say, for example, we're concerned, or we have the right to disqualify someone if they're incompetent, right? But that judgment could be made at the beginning when they're just being admitted into the practice for the agency, or it could result from something that happens during the course of the proceeding. So sometimes there's a little bit of blurring of those lines between what's a qualification or credential and what's a conduct issue.
So I have two thoughts on that. Then maybe this is where we can distinguish, take away from that other section that, there seem to be conduct and prerequisites, and just leave those as conduct and move those prerequisites over here to this qualification section. And then I wonder if instead of qualifications, a word like prerequisites could be used. I don't know if that's even the right word, but something that indicates that these are the standard. These are the standards you have to meet before you can even appear. That would help clean up that other section.
Well, I'm sorry, go ahead.
Now, if we move some of that out of there and just left the other ones with conduct during the proceeding, that would help clean that up. We may not need the language then that you were tasked with coming up or volunteered to come up with.
Well, we're talking about two different things. We're talking about, on one hand, we're talking about, in a sense, binary characteristics. I mean, you either have a law degree or you don't. On the other hand, we're talking about competence in a particular area of the law, which is more discretionary, or conflict of interest. I mean, as Professor Cohen pointed out, that can vary.
I guess I was just trying to distinguish between behaviors that have happened before you even get to the proceeding and behaviors happening during the proceeding that seem to be of concern.
Right.
And are we comfortable being prescriptive here in terms of agencies should establish qualification requirements for non-lawyer representatives as opposed to some of our other?
That's true also in 7.
Should consider, or
and you have to make 6 and 7 parallel, because 6 is also prescriptive, should not require. Whether to require,
and
consider whether to require, something like that. So just so the
Well,
parallel.
six
Yes.
is a different issue because there's a legal.
Yes, that is different. Because I think that's,
Well, should consider whether to require any qualifications other than those.
but it sounds like we can't, they can't, is that what I'm,
Yeah, they're limited. in
they
what
can't, they're limited,
with
so
respect to lawyers by the
we need
statute.
to, by statute, so we need to keep that.
It's in some ways, 6 is merely a restatement of
Yes.
5 USC 500.
Yes,
I
we
see.
may want to make that, clearer. In other words, I'm not ready to wordsmith, but just in the case of lawyer, 5 USC section 500 requires that, or just to make clear that this is not coming from us, but that it's a statement of the law.
Well, agencies are bound by 5 USC 500,
Right.
which requires.
Right.
Okay, the Committee on Style can reword that to make it
Thank
more
you.
clear that the 500 basically controls in this area.
Yes, thank you.
As to Carrie's other point, I mean, Committee on Style can also attempt a redraft or a recategorization. I think what Russell or George mentioned, it will be interesting in that some of the categories would obviously apply to both the antecedent recognition or appearance rules, what we're calling qualification, and then they would also equally apply to conduct rules in the midst of one's representation. So there may be some duplicativeness, but I think that is what the committee, that's the sense of the committee as I understand it. Great. Allison, I think unless there's further on this, I think I can attempt to, the Committee on Style can attempt to redraft on these portions then.
Yes. Yes.
Time's running short, so I would suggest we keep
Yes.
moving.
Yes. I know that we have a staff comment about providing more detail or maybe building out some of these a little more.
Drawing on what the ABA said previously, would it be too limiting to say something like rules should address what sanctions an agency may impose? Because sanctions, I think, was the term of art that previously was suggested for this type of thing.
Agree with that, because actions can, be a whole litany of potential things like I talked before about warnings or reminder letters. And I think the focus really is on the regulatory disciplinary type proceeding that's going to occur. That's really what the representatives are most concerned about in terms of avoiding, and the agency is most concerned about in terms of the egregiousness. I don't know that providing more detail, unless a particular agency wants to do that, is something that's strictly necessary.
Russell?
Russell?
Yeah, I just asked the question of whether or not discipline is the right heading. I go back to the conversation at the start of our session, and what was just referenced. Actually, I mean, you can deal with a representative who's not performing up to par by disciplining them, but you can also counsel them or something short of discipline. So do we want to restrict this just to discipline, or is it a matter of dealing with problematic behavior? I mean, discipline connotes punishment, really. even a violation of agency rules, depending on the violation, may not call for a disciplinary action. It could be an unknown violation, for example, and a violation of which one is unaware, in which case, I presume you take the representative aside and say, this is where you had a problem, you don't do it anymore.
So maybe the heading instead of discipline could be agency action.
Something like that. Agency action in response to potential to
Violations or
to misconduct. Or violation of rules.
Unless there's nothing further on that point, I would re-raise the point for the committee's discussion about whether or not the range of disciplinary actions or the range of agency actions should be spelled out any further than that.
Well, you could. I'm always in favor of more examples to put flesh on these things. So my fallback answer is always yes to that. But here, at least you could, as I said before, you could, consider whether the violation was knowing or unknowing. For one example.
Just one question. I have if I may jump in, just one question, and maybe it's not something to be addressed today, but the ABA, I think it was Ellen, had raised in the discussion of what's discipline. There was a discussion of sanctioning versus discipline. The committee may want to sort of parse that out at some point.
I believe the ABA resolution uses the language exercise of disciplinary authority in their resolution.
Well, I'm not so concerned about the terminology as much as what exactly are we talking about here in terms of discipline.
Agreed. I think to Judge Sokajewski's point, there is value to incorporating other actions which may or may not be considered disciplinary, such as a letter. I think that's the sense of the committee.
Yes, and to Matt's point, 11, how the disciplinary process works, among other topics that are who can make a complaint and how they can make it, sounds broader to me than what we've been focusing on in terms of things that happen during an adjudicative proceeding. So that maybe that's just something in the spirit of Matt's question that we need to think through here, that may just need to be narrowed or clarified in terms of what we're talking about, particularly with respect to 11. Not to jump ahead, but it seems like it's all interrelated.
I think that the Committee on Style can consider drafting language in response to that. I would seek a little more clarification about the distinction that's being made about sanction versus discipline versus action. Would the committee like to go broader and characterize things more in terms of actions, just to include all other types of items, or to be more specific and to limit it to sanction or discipline, but to be more accurate about the specific term? Is there a sense of the committee on that?
if you retain the broader action, I suppose that referral to a state bar is an action and not an actual form of discipline by the agency. So maybe action is better. And maybe you include here something like such actions may include referral to a relevant state bar or sanctions or discipline such as reprimand, suspension, things like that. Oh, I was going to suggest that might be the such actions may include in 9, but
I would add, get in there sometimes the idea that sometimes non-punitive actions are appropriate.
I guess that would include counseling or up to a warning letter or something like that.
Yeah.
What was the first you mentioned?
I think there was a mention of counseling, which is,
Yeah.
So what we do generally is a reminder letter. And then if that doesn't work, OGC might send a warning letter. So you might want to just include that. Reminder letter go before, and counseling is misspelled, by the way.
So I see that we're at 1 Eastern. I want to be respectful of everyone's time, but it does seem like we have some more important issues associated with this to discuss. So unless anybody has sort of anything they really want to get out now, I would suggest that we preserve this to go back to at our next meeting, in addition to moving on with the transparency. Gavin, does that sound? Gavin,
Yeah, we can
sound good?
we can restart, I think, the considerations in this section. Obviously, we'll want to revisit whatever changes the Committee on Style made in the prior sections.
Yes.
But I think going forward, beginning at the next meeting would be a good course of action.
Okay. Okay. So again, our next scheduled meeting is Monday, November 8th at 10 a.m. Sounds like we also have some potential reading assignments, other materials that have been mentioned during the meeting today that might be helpful for us to peruse between now and then. Gavin or Matt, anything you'd like to say or add before I close this out?
No, I don't think so. Thank you so much, Allison and Carrie as well.
All right. Thanks everyone very much. Have a good weekend and we'll see you at the next meeting.
Thank you.
Thank you.
Thank you.